speech, complained that Article 5 was not a constitutional convention and that it couldn't change the Constitution in all the fundamental ways that he wanted to do. So, historically, textually, from the words of the founders and the ratifiers, there's just no way to conflate the two if you think any of that matters. And that leads to the other question. If you don't think the Constitution matters, if you don't think the text matters, the original meaning matters, then of course you can have any old constitutional convention you want. We could have one right now. That can never be constrained. And that's something I'm not arguing against.
John, did you want to?
I think there is a distinction in terms of what they understood by a convention. I think it can be established, but I don't think there is any way to authoritatively establish that today. I mean, I think academically you can establish it, but as Professor Tribe, I think, has convincingly shown, there's no authority to establish it. And that's where the confusion comes in. There is no ground rule to establish that. And it's because of that that I oppose a constitutional convention. If it were as I think they intended it, I would be comfortable with it. But I don't think it will be as they intended it.
I just got to follow up with that. There has to be a first time for everything. There was a time when, my God, we've given each chamber of Congress rule-making authority. How do we know they're not going to have minority rule? How do we know they're not going to deviate from all the history and practice that had existed before? I mean, every question, I suppose I'm sounding like I have chutzpah, but forgive me for this, Professor. I mean, the bottom line is every question you have directed to Article 5, you could target to every single procedure in the lawmaking process when it was first done for the first time. And so, that is not a legitimate criticism.
No, it is, because there's been a big difference. The time of the convention, there was very little case law, and there was custom. Today, we are governed by very little custom, and we're governed by case law. And we have a lot of case law developed over more than 200 years. We don't have this, and we don't have time to do it. There are too many issues up in the air, and there's no authoritative ways to resolve it.
So I'd like to ask Barbara, and I'm going to come back to you. Barbara, in your book with Professor Weber, as Professor Tribe suggested, you tried to introduce what you called political constraints that might help address some of the uncertainties that Professor Tribe has enumerated. And I wonder whether that helps us understand whether there is such a distinction between Article 5 conventions and regular conventions, or how that might play out.
I'm not sure about that specific point, but again, I think Paul, being the eternal optimist, everything with the glass was always half full with him. To Professor Tribe's point about the Supreme Court, that, as you remember, was one of Paul's suggested